Hi, everyone. Thank you. Welcome to the Billy Wilder Theater. I'm Claudia Bester. I'm the Director of Public Programs here at the Hammer Museum, and I want to welcome you all to tonight's talk with UC Berkeley Law School Dean Erwin Chemerinsky on the idea of originalism in interpreting the U.S. Constitution. The Hammer Forum is a monthly series of public discussions about current social and political issues, and it's made possible with the generous support of the Rosenblum family. Tonight is the third of a three-part lecture series on the current and future state of the United States Supreme Court and the cases it's considering that will affect all of our lives. In the first talk in January, Dean Chemerinsky addressed the Supreme Court decisions that were released in the last court session, especially those related to abortion rights, religion, the right to bear arms, and the administrative state. Then in February, he addressed the cases that the Supreme Court is currently considering. One is the fate of affirmative action, which our current Supreme Court is likely to rule against. One is about the separation of church and state, which this Supreme Court is likely to overrule, and they're likely to allow businesses to discriminate on the basis of race, sex, religion, or sexual orientation if they claim it's based on their religious beliefs. Another decision they will issue soon has to do with voting rights and the laws that some states are putting into place to make it more difficult for minorities to vote. The current Supreme Court is likely to say that's just fine with them because they'll claim states have the right to conduct elections however they please. And in an incredibly important related case, this current Supreme Court is likely to say that it's the right of individual states to gerrymander and manipulate their voting districts as much as they wish, which could have devastating effects on local and national elections, including presidential races. Because of their use of an originalist framework called independent state legislative theory, based on a handful of words comprising the Elections Clause, which you will find on page 7 of your constitutions that you received today on your way in. The election clause, the latter two cases are very linked to the topic of tonight's talk on the theory of originalism in interpreting the United States Constitution. And by the way, all of these talks will be available on the Hammer channel, the Hammer website, and you can share them there with your friends and colleagues. As you'll see shortly, Dean Chemerinsky is a brilliant legal scholar who literally wrote the textbook on constitutional law. His most recent book is called Worse Than Nothing, The Dangerous Fallacy of Originalism, and in it he talks about how what was once the fringe theory of a few extremely conservative legal scholars has become a well-accepted mode of constitutional interpretation. Just as the Christian fundamentalist movement believes that the Bible in its entirety is the literal word of God, and as such it must be interpreted as literal truth in all its details, the originalism theory of the Constitution argues that the U.S. Constitution, written in 1787, must be interpreted with a strictly literal reading of the words and only as a way to understand the intent of the 55 men who wrote it. This is why we felt it was important to give each of you in the audience tonight your own pocket-sized copy of the Constitution and the Bill of Rights with your tickets tonight, so you can read the actual original text for yourselves. Our guest speaker is the rock star of the legal world. Erwin Chemerinsky is Dean and Distinguished Professor of Law at the UC Berkeley School of Law. Before assuming his current position, he was the founding dean of the University of California Irvine School of Law and a professor at Duke Law School, USC Law School, and DePaul Law School. He's the author of 15 books and over 200 law review articles and frequently argues appellate cases, including in front of the United States Supreme Court. A study of legal publications found he's the most frequently cited American legal scholar, and the National Jurist magazine named him the most influential person in legal education in the United States. His books include Interpreting the Constitution, Constitutional Law, Principles and Policies, The First Amendment, The Religion Clause, The Case for Separating Church and State, The Conservative Assault on the Constitution, The Case Against the Supreme Court, We the People, A Progressive Reading of the Constitution for the 21st Century, Closing the Courthouse Doors, How Your Constitutional Rights Became Unenforceable, Free Speech on Campus, co-written with Howard Gilman, Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights, and his most recent book, as I just mentioned, published in 2022 by Yale University Press, is called Worse Than Nothing, The Dangerous Fallacy of Originalism. Now, despite being such a renowned academic and scholar, Chemerinsky is able to translate legalese into crystal clear language we can all understand. And I just want to take this moment to say that I'm incredibly grateful to him for taking 3 entire nights of his precious time to fly all the way here to Los Angeles and speak to the Hammer audience. He's just incredible. Also, I should mention that after tonight's talk and audience Q&A, we're going to have some light refreshments out in the theater lobby, and we'll have copies of his books for sale, and he'll be happy to sign them for you. So without further ado, please join me in welcoming Erwin Chemerinsky.
Thank you so much for the kind introduction and the warm welcome. It's truly a momentous time in the Supreme Court. The Supreme Court's recent decisions and soon-to-come decisions will affect all of us, often in the most intimate and important aspects of our lives. I want to thank the Hammer Museum and Claudia for inviting me to do this 3-part series. When I was thinking about how to organize it, I decided to focus it on the recent past, the present, and the future. So the first lecture on January 22nd talked about how we got to the current court. Between 1960 and 2020, there were 32 years with a Republican president and 28 years with a Democratic president, almost exactly even. But between 1960 and 2020, Republican presidents picked 15 justices, while Democratic presidents picked only 8 justices, an almost 2-to-1 difference. Or to put it another way, President Donald Trump picked 3 justices during his 4 years in the White House. The prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, and Barack Obama, served a combined 20 years in the White House, and in those 2 decades, they picked only 4 Supreme Court justices. And so in the first lecture, I focused on 9 days in June of 2022. On Tuesday, June 21st, in Carson versus Macon, the Supreme Court said, whenever the government provides money for secular private schools, the Constitution requires that it subsidize religious schools. 2 days later, on Thursday, June 23rd, the court decided New York State Rifle and Pistol Association versus Bruin. The court said there's a Second Amendment right to have guns in public, including concealed weapons. The court said the only regulation of guns will be allowed are those that were historically permitted in 1791 or maybe 1868. The next day, Friday, June 24th, the Supreme Court decided Dobbs versus Jacksonville Health Organization. The court expressly overruled Roe versus Wade. The court said that the issue of abortion rights is left to each state. If states wish, they can completely prohibit abortion. 3 days later, on Monday, June 27th, in Kennedy versus Bremerton Schools, the Supreme Court said that a high school football coach had the First Amendment right to go onto the field after games and kneel and pray. The court said it violated his free exercise of religion and free speech to forbid him from doing so. And 3 days later, on Thursday, June 30th, the Supreme Court decided West Virginia versus Environmental Protection Agency and ruled that the Environmental Protection Agency lacked the authority under the Clean Air Act to regulate greenhouse gas emissions from coal-fired power plants. This is a major source of the pollutants that are leading to climate change. It's hard for me to think of any 9 days in all of American history that was momentous for the Supreme Court. It's just this, days under less than 2 weeks in American history. Well, in the second lecture, on February 22nd, I looked at this year of the Supreme Court and what we can expect. And as Claudia reviewed, I talked about how the Supreme Court has heard oral arguments and is likely between now and the end of June to end affirmative action by college and universities across the country, is likely to make it far more difficult to prove that race discrimination violates the Voting Rights Act, and for the first time in history to say that people have the right to violate anti-discrimination laws based on their speech and religious interests. Well, having in the last couple of lectures talked about the recent past and the current term of the court, I want to use this lecture to look at the future and what we can expect from the Supreme Court. I think in order to understand the future of the Supreme Court, it's important to focus on the theory that animates most of the justices, and that's originalism. I want to talk about what's wrong with originalism. I want to talk about why we should all be afraid of originalism. And then I want to conclude this lecture series by looking ahead and talking about what we can do to make a difference in light of a very conservative Supreme Court. Well, what is originalism? Originalism is the view that the meaning of a constitutional provision is fixed when it's adopted. It can be changed only through a constitutional amendment. So if we were focusing on Article 1 of the Constitution that gives Congress powers, an originalist would say it means the same thing today it was adopted in 1787. Or if we're focusing on one of the provisions of the Bill of Rights, like the First or the Second Amendment, an originalist would say it means exactly the same thing today as was adopted in 1791. The 14th Amendment is one of the most important provisions of the Constitution. It applies the Bill of Rights to state and local governments. It's what says state and local governments cannot deny any person equal protection of the laws. An originalist would tell us that the 14th Amendment means exactly the same thing today as was adopted in 1868, and if it's to be changed, it should be only through the constitutional amendment process. It's not that long ago, in 1987, that Robert Bork was rejected for a seat on the Supreme Court by the United States Senate because of his originalist views. Bork was impeccably qualified to be a Supreme Court justice. He had been a law professor at the University of Chicago and at Yale. He had been the Solicitor General of the United States. That's the lead lawyer in the Justice Department who represents the federal government before the Supreme Court. And at the time of his nomination, he was a judge on the United States Court of Appeals for the District of Columbia Circuit. But 58 senators, Democrats and Republicans, voted against the confirmation of Bork. More senators voted against Bork's confirmation than have ever voted against any nominee's confirmation in all of American history. They did so because he was a self-avowed originalist. Bork had said that the meaning of a constitutional provision is fixed when it's adopted, and it changes only by amendment. So Bork had said repeatedly that there's no protection of privacy rights in the Constitution, that the Supreme Court was wrong to find a right to purchase and use contraceptives, a right to abortion, because that wasn't part of the framers' intent. Bork said there's no constitutional protection under equal protection for women against discrimination. He said those who wrote the 14th Amendment were focused just on race discrimination. Sex discrimination doesn't violate that provision. Bork said that the First Amendment and its protection of free speech only safeguards political expression, not speech for entertainment or anything else. Now, not that many years later, there are 3 justices on the Supreme Court who are self-avowed originalists: Clarence Thomas, Neil Gorsuch, Amy Coney Barrett. Each of them at their Senate confirmation hearings embraced originalism. When Amy Coney Barrett was considered for a seat on the Supreme Court in October of 2020, she told the senators that Justice Antonin Scalia's judicial philosophy is her philosophy, that she believes that the Constitution should be interpreted solely based on its original meaning. And there are 3 other justices on the Supreme Court, Chief Justice John Roberts, Justice Samuel Alito, and Brett Kavanaugh, who often join the originalist opinions. They often write their own opinions in originalist terms. And increasingly we find that even the liberal justices on the court look to what was the meaning of the Constitution was adopted in deciding particular cases. So, as you understand the future of the Supreme Court, it's important to look at originalism. And I want to suggest to you that originalism is a terrible way of interpreting the Constitution. I want to suggest to you that it's very dangerous in terms of what it's going to mean for all of us and our rights in American society. Let me identify several problems with originalism. One I would call the abhorrence problem, that if originalism is followed, it leads to truly abhorrent results. Let me give you some examples and then explain them. Brown versus Board of Education, Loving versus Virginia, Obergefell versus Hodges, the prohibition of sex discrimination. None of those can be justified under an originalist theory. Let me start with Brown versus Board of Education. For me, if anything is the quintessential Supreme Court case in terms of its role in society, it's that decision that came down on May 17, 1954. As you know, in 1896 in Plessy versus Ferguson, the Supreme Court upheld the pernicious doctrine of separate but equal. The court said that didn't violate equal protection. And after Plessy versus Ferguson, Southern states adopted Jim Crow laws that imposed apartheid in every part of life. In Southern states, many Borden states, southern parts of northern states, laws were adopted that required that black and white children be born in separate hospitals, play in separate playgrounds, drink from separate water fountains, use separate bathrooms, attend separate schools, eat in separate restaurants, ultimately be buried in separate cemeteries. It wasn't until 1954, in Brown versus Board of Education, that the Supreme Court finally said, the area of education, separate can never be equal. Following Brown, the Supreme Court, in a series of decisions, struck down all of the other laws that imposed segregation in so much of the country. But there's no way to justify Brown versus Board of Education from an originalist perspective. The same Congress that voted to ratify the 14th Amendment also voted to segregate the District of Columbia public schools. There is not a shred of evidence that the Congress that ratified the 14th Amendment or the states that approved it meant to outlaw segregation. Loving versus Virginia. This is a decision from 1967 that declared unconstitutional a Virginia law that prohibited interracial marriage. At the time the 14th Amendment was adopted, almost every state had a law prohibiting interracial marriage. It might surprise you to know that California had a law prohibiting interracial marriage until 1948, when it was struck down by the California Supreme Court. In 1967, when Loving was decided, 16 states still had laws that prohibited interracial marriage. Nonetheless, the Supreme Court, in a non-originalist decision, held that laws that prohibit interracial marriage violate equal protection. Obergefell versus Hodges, this case that came down on June 26, 2015. It held that states cannot prohibit same-sex marriage. The Supreme Court said that the right to marry has long been regarded as a fundamental right, that gay and lesbian couples should have the same right to equal dignity under the law that heterosexual couples have always enjoyed. The Supreme Court found the laws prohibiting same-sex marriage to deny equal protection, to violate the liberty and the Due Process Clause. And of course, there's no way to argue that this decision could be justified from an originalist perspective. Or the constitutional prohibition of sex discrimination, or discrimination on the basis of sexual orientation or gender identity. Justice Scalia said on many occasions that he believed that the Constitution didn't prohibit sex discrimination because that wasn't the original meaning of the 14th Amendment when it was adopted. I posit for you tonight that any theory of constitutional interpretation that makes illegitimate Brown versus Board of Education, Loving versus Virginia, Obergefell versus Hodges, and the constitutional prohibition of sex discrimination is one that we should reject. There's a second problem with originalism that I identify, and I call this an epistemological problem. So many people were involved in drafting and ratifying the Constitution. It's a myth to say that there was an original meaning behind what they were doing. I'm teaching constitutional law this semester at Berkeley, and I like to point to all of the instances in which Alexander Hamilton and James Madison disagreed. We regard them as the paradigm framers. We look to their writings, their essays in the Federalist Papers, as guidance to framers' intent. But they disagreed about so much. Just this week in constitutional law, I was talking about their views on the question of whether the president has inherent powers, whether the president can act without constitutional or statutory authority. In 1797, early in American history, in the presidency of George Washington, a dispute arose. There was a war going on between England and France, and George Washington wanted to issue a neutrality proclamation. He thought that our fledgling nation had nothing to gain and much to lose by taking sides in the war. So he turned to his advisors, including Alexander Hamilton and James Madison. They had been part of the Constitutional Convention in Philadelphia in 1787. Hamilton said the president has inherent powers. Madison strongly objected and said that the Constitutional Convention meant to reject royal prerogatives and inherent powers. If Madison and Hamilton couldn't agree in 1797 as what the Constitution meant, how can we believe we're going to be able to discern the framers' intent or the original meaning today? I had an experience here in Los Angeles about 25 years ago that illustrates the difficulty of ever trying to figure out what was the original meaning of a document. If you were in Los Angeles then, you might remember that in 1997, voters approved an elected commission to propose a new charter for the city. The city council had already created its own appointed commission. The city charter in Los Angeles and throughout the state is much like the constitution of the city. It creates the institutions of city government, it allocates power among the branches, it even can provide more rights than the state constitution or the U.S. Constitution. I ran for election from the 5th Council District in Los Angeles, and amazingly, I was chosen, and then I was selected by fellow commissioners to be the chair of the commission. And we worked very hard over 2 years to draft a new charter. The appointed commission did as well. If you were here then, you might remember, finally we pulled them together into one unified charter, about 100 pages long. It went to the voters, and they approved it in June of 1999. It continues to be the charter for the city of Los Angeles. Immediately, issues began to arise as to what we meant. Almost always, the questions were ones we never thought about or talked about. Occasionally, there'd be a situation where I'd get a question from the city attorney or a lawyer saying, "What did you think about this provision?" And if they liked my answer, they'd say, "Would you write a declaration?" And if they didn't like my answer, they would keep calling other commissioners to that one who said what they wanted. One of the first cases to come up involved the meaning of a term limits provision. And it was one issue we never thought about or talked about. Nonetheless, the California Court of Appeal, in resolving the issue, said the intent of the voters with regard to this sentence decides the case. I am reasonably certain that not a single voter in Los Angeles focused on that sentence in a 100-page document. It was merely a fiction to talk about the intent of the voters. Likewise, what you find when the justices engage in originalism is they look back in history to find support for the conclusions they already want to come to. The late Judge Patricia Wald said, engaging in this kind of history is a lot like going to a cocktail party. When you go to a cocktail party, you look to find your friends. When you engage in this kind of history, you look through the historical record for the scraps that support the conclusion you want to come to. Lest you think this sounds too cynical, reflect on the cases that I mentioned from that 9-day period in June of 2022. The Supreme Court, based on looking at the original meaning of the Constitution, found a constitutional duty of the government to support religious schools, found a great limit, unprecedented restrictions on the ability of the government to regulate guns, no abortion rights in the Constitution, a right of a teacher to go on the field at football games and pray, and no power of the EPA to regulate greenhouse gas emissions. Unless you believe that the framers' intent in 1787 is the same as the Republican platform today, it's clear what's going on. The justices have their conservative conclusions, and then they look back to find the evidence to support them. But inevitably, there's this epistemological problem because we're never going to know what was the original intent. There wasn't a single intent behind any of the provisions in the Constitution. There's a third problem that I identify with originalism, and I would call it the incoherence problem. I think there's a strong argument that the framers of the Constitution didn't intend their views to be controlling. When the framers met in Philadelphia in 1787, they immediately decided to operate entirely in secret. They would not allow any outsiders there. They even nailed the windows shut so no one could hear what they were doing. They had been convened to amend the Articles of Confederation, but chose quickly to draft a new constitution. James Madison took the official notes. He instructed that they not be revealed publicly until after his death. There are many statements by Madison and others that the Constitution was meant to stand on its own. The late Chief Justice John Marshall, who was one of the drafters in Philadelphia in 1787, wrote in 1819, and I quote, "We must never forget that it's a Constitution we're expounding, a Constitution meant to be adapted and endure for ages to come. I cannot think of a clearer, more emphatic rejection of originalism than the words of John Marshall." But then this leads to a very elegant argument against originalism. If one is committed to following the framers' intent, and their intent was their views not be controlling, doesn't that mean that if you follow originalism, you have to abandon originalism? Jeff Powell, a law professor at Duke, wrote an article in the Harvard Law Review almost 40 years ago called "The Original Understanding of Original Understanding," where he made this argument. Boris Bitger, a law professor at Yale, made the same argument. Now, there is a difficulty with this argument, but it's also a difficulty with regard to originalism. It's impossible to know what the framers of the Constitution thought is how the court should exercise judicial review. That's because the Constitution doesn't say anything about judicial review. Article 3 of the Constitution creates the Supreme Court and allows Congress to create inferior courts. But nowhere in Article 3, nowhere in the entire Constitution, does it say that courts have the power to review the constitutionality of statutes or executive actions. That power comes from a single Supreme Court case, Marbury versus Madison, in 1803. So it's impossible to know what the framers thought is how courts should engage in judicial review because the Constitution doesn't speak of judicial review. There was no talk about judicial review at the Constitutional Convention or the state ratifying conventions. That said, everything we know about the framers' intent was that they meant to create a constitution written in broad, open-ended language that can endure and survive. They didn't mean for their views to be controlling. There's a fourth problem that I identify with originalism, and that's the modernity problem. The world today is so vastly different from 1787, when the Constitution was written and adopted, so different than 1868, when the 14th Amendment was adopted. How can we really expect to be limited to the views of those who lived then? Why should we want to be limited to the views of those who lived then? Again, I can give a number of illustrations of this. There was a Supreme Court argument about a decade ago. It was a case involving a California law. It prohibited the sale or rental of violent video games to minors under 18 without parental consent. A case called Brown versus Entertainment Merchants. And Justice Scalia was grilling one of the attorneys in oral argument. And finally, Justice Alito interrupted and said, "What Justice Scalia really wants to know is, what did James Madison think about violent video games?" Of course, merely to ask the question is to see the absurdity of originalism. Or take the example that I mentioned earlier, the decision from June 27th in Kennedy versus Bremerton Schools. The issue is, does a high school football coach at a public school have the right to go on the field and pray after games? For over 60 years, the Supreme Court had held that prayer in public schools violates the Establishment Clause of the First Amendment. The Supreme Court overruled the leading case that articulated a test of this And Justice Gorsuch, writing for the majority, said, determining what violates the Establishment Clause should be on the basis of, quote, and I'm quoting, the views of the founding fathers. So here's the question. What did the founding fathers in 1791 think about a high school football coach at a public school going on the field and praying after games? Again, merely to ask the question shows the absurdity of this. Or one more example, a particularly important Supreme Court case from just a few years ago about the Fourth Amendment. The case is Carpenter versus United States. Let me tell you a little bit about it. Timothy Carpenter was a suspect in a number of armed robberies. Ironically, many of them were of Radio Shacks. When I taught this case last fall, I had to explain to my students what a Radio Shack used to be. But when I taught another case about the Fourth Amendment, I had to explain what a phone booth used to be. The key evidence against Timothy Carpenter was his cellular location information. Anytime our cell phone is on, it automatically connects with cell phone towers. Doesn't matter whether we're scanning the web, sending emails, or even our phone is just on in our pocket. It's always connecting with cell phone towers. So a crucial form of evidence for the police is to get the cellular location information. And here, the federal authorities got 127 days of Timothy Carpenter's cellular location information. And through it, they could show that whenever there were one of these armed robberies, his cell phone was nearby. And he was convicted. He was given a very long prison sentence, 119 years in prison. And the question before the United States Supreme Court was, did the police need to get a warrant before obtaining the cellular location information? The Supreme Court 5-4 said yes. Chief Justice Roberts was joined by the 4 liberal justices on the court, Justices Ginsburg, Breyer, Sonora, and Kagan. But the originalist justices dissented. Justice Thomas said that the only things that should violate the Fourth Amendment is when there's a physical trespass on somebody's property without a warrant. Justice Gorsuch, an originalist, took that view too. And since obtaining cellular location information doesn't involve a physical trespass, it's not a search. Now, Chief Justice Roberts rejected that view. Chief Justice Roberts said that we can learn a great deal of private information about somebody from their cellular location information. You can see what doctor they're going to visit, who they're going to see, where they're going to worship. And the Supreme Court said if the police want to obtain a large amount of cellular location information, they've got to go to a warrant first. They've got to have a judge approve this. I do not think that Carpenter would be decided the same way today. Since Carpenter was decided, Justices Kavanaugh and Barrett have come on the court, I think there would be a majority to say that if there's not a physical trespass, there's not a search. Justice Thomas says that's the only thing that the framers back in 1791 thought would constitute a search. But think of all the ways that the government can gather information about any of us without a physical trespass. Wiretapping that doesn't involve going on our property. Satellites that monitor what we're doing. Cellular location information, and so on. And what frightens me about the shift in the composition of the Supreme Court is the likelihood that the originalist perspective, a very restrictive view of the Fourth Amendment, is likely to control. Or in talking about the modernity problem, think again about the Second Amendment. Justice Thomas, in the case I alluded to in my introduction, New York State Rifle and Pistol Association versus Bruin, was explicit that the only kind of gun control regulations that should be allowed are those that were permitted in 1791. There weren't AR-15s or similar weapons of mass destruction in 1791. Why should that mean that the government can't regulate those weapons today? Or about a month ago, the United States Court of Appeals for the Fifth Circuit handed out a decision based on Justice Thomas' opinion. There's a federal law that says that people who are under restraining orders in domestic violence cases are not allowed to have a firearm. There's a good deal of evidence that this has saved many people's lives, especially lives of many women. But the United States Court of Appeals for the Fifth Circuit, judges appointed by President Donald Trump, said that the only kind of gun regulation should be allowed are those that were permitted in 1791. And they said in 1791 there were no laws that said that people under restraining orders in domestic violence cases couldn't have firearms, and thus they declared unconstitutional the federal law. Of course, in 1791, there was very little that protected the rights of women, especially married women. Married women were considered the chattel, the property of their husbands. A married woman in 1791 could not own property or enter in a contract. Why should the views in 2023 be limited to what people thought in 1791? That's what I see is the modernity problem. There's a fifth problem that I would identify with originalism, and I would call this the hypocrisy problem. And I've already alluded to it. Originalist justices abandon originalism when it doesn't get to the results they want to come to. I'll give you a couple of examples. One is Citizens United versus Federal Election Commission, a decision from 2010. Justice Ruth Bader Ginsburg gave a speech in San Diego where she said she thinks history will regard this as one of the worst Supreme Court decisions of all. In Citizens United versus Federal Election Commission, the Supreme Court ruled that corporations have the right to spend unlimited amounts of money from corporate treasuries to get candidates elected or candidates defeated. The 5 conservative justices were the majority in a 5-4 decision. All of the self-avowed originalists then in the court joined in. But as Justice Stevens pointed out in dissent, corporations, as we know them today, didn't exist in 1791. Even more important, campaign spending as it exists today didn't exist in 1791. So how is it possible, based on originalism, to say that a law restricting corporate spending in elections violates the First Amendment? Of course, there is no originalist way to justify it. What the conservative justices did was follow their conservative views and strike down the federal law. There's now a large body of political science literature about the pernicious effects of the court's decision in Citizens United, especially in state and local elections, where there's less name recognition of the candidate. Corporate spending makes an enormous difference in who wins and who loses. Or one more example with regard to the hypocrisy problem, and it's what I talked about when I was here on February 22nd, the Supreme Court's affirmative action cases. These are 2 cases that were argued on Monday, October 31st, 2022. Students for Fair Admission versus University of North Carolina, Students for Fair Admission versus Harvard College. Since 1978, the Supreme Court has said that college universities have a compelling interest in every diverse student body. College universities may use race as one factor among many in admission decisions to benefit minorities and enhance diversity. I don't think anyone, liberal or conservative, has doubts that the Supreme Court is going to overrule those years of precedent and is going to eliminate affirmative action by colleges and universities. What I want to focus on here is the originalism aspect of this. The same Congress that ratified the 14th Amendment adopted many race-conscious programs that today we would call affirmative action. They adopted things like the Freedmen's Bureau. Many constitutional scholars have persuasively argued that from an originalist perspective, affirmative action should be allowed. And yet I have no doubt that the originalist justices on the court are going to vote to end affirmative action. If you look at their dissenting opinions in the cases that allowed affirmative action, never once do they talk about the framers' intent from 1868. In other words, they abandon originalism when it doesn't get to the results that they want. So these are all of the reasons why I think that originalism is an undesirable way of approaching the United States Constitution. I also think it's a very dangerous way of approaching the Constitution. Some of that's implicit in what I said. the kind of laws that will be allowed or not allowed solely because of the views that existed in 1787 or 1791 or 1868. But it's also the case that throughout American history, the Supreme Court has rejected originalism. What will it mean for these decisions to have a profoundly originalist court? I want to be specific. The Supreme Court, over the last century, has protected under the liberty of the Due Process Clause many rights that are nowhere stated in the Constitution and were not part of the original intent. The right to marry, the right to procreate, the right of parents to the custody of their children, the right to keep the family together, the right of parents to control the upbringing of their children, the right to purchase and use contraceptives, the right of consenting adults to engage in private same-sex sexual activity, the right of competent adults to refuse medical care. None of these rights can be justified from an originalist perspective. None are mentioned in the text of the Constitution. None were part of the framers' intent in 1787 or 1791 or 1868. If the court were to follow originalism, all of these rights, precious aspects of each of our liberty, will be in danger. Lest you think that here I'm exaggerating or engaging in hyperbole, I want to direct your attention to an opinion from June 24th, 2022, written by Clarence Thomas. This was written in Dobbs versus Jackson Women's Health Organization, where the Supreme Court overruled Roe versus Wade. Justice Thomas, in his opinion, said, "Now that the court has overruled Roe, it should overrule Griswold versus Connecticut, the case that held that there is right to purchase and use contraceptives, Lawrence versus Texas, the 2003 case that said states cannot criminally punish private, consensual, adult same-sex sexual activity, and Obergefell versus Hodges, the 2015 case where the Supreme Court said states can't prohibit same-sex marriage." Justice Alito, in the majority opinion, said, "None of those rights are in jeopardy because none involve potential life." The dissent said, "The majority is telling us Scout's honor, don't worry about it." But I think we need to be worried. At the beginning of his majority opinion in Dobbs, Justice Alito said, "A constitutional right should be protected only if it's in the text, part of the original meaning, or a long unbroken historical tradition." None of the rights that I mentioned to you a moment ago would fit into those criteria. And with a court so committed to originalism, it's easy for me that they will re-examine, say, Obergefell versus Hodges and the constitutional protection for same-sex marriage, or even Griswold versus Connecticut, which protects the right to purchase and use contraceptives. If not originalism, then what? Justice Scalia was fond of giving speeches where he said, "I have a theory, they don't." In fact, it was that statement that led to the title of my most recent book, Worse Than Nothing, The Dangerous Fallacy of Originalism. The reality is that throughout American history, until very recently, the Supreme Court has been non-originalist and has considered many sources in interpreting the Constitution. All justices start with the text of the Constitution, but the text rarely provides answers for the cases that come before the Supreme Court. What's cruel and unusual punishment? What does due process of law mean? What's required by free exercise of religion? The text isn't going to provide answers. It's certainly worth looking and seeing what the framers were thinking in 1787 or 1791 or 1868. That doesn't mean we're bound by their thoughts. It doesn't mean they're determinative. Sometimes the structure of the Constitution can help provide answers. Looking at history and tradition might be useful. Looking at precedents and what the court's decided matters. Precedents, the rule of stare decisis, provides some stability and predictability in the law. But also it's important to look at modern social needs. One of my criticisms of the decisions from last June is how much the conservative majority paid no attention to modern social needs. So in the Second Amendment case, Justice Breyer began his dissent by talking about the toll of gun violence in the United States, including the recent mass shootings. Justice Alito, in a concurring opinion, mocked and ridiculed Justice Breyer for focusing on that reality. But shouldn't the modern social needs influence how the Second Amendment is interpreted? Or in the case about the EPA's authority to regulate greenhouse gas emissions, Justice Kagan began her dissent by talking about the existential threat to the planet and all life on it from climate change. There's not a word about this in the majority opinion. And so what I argue for is the Supreme Court should do what it's always done. Look to multiple sources to decide the best meaning of the Constitution. Now, admittedly, this means that there's not going to be a determinate way of resolving constitutional issues. But a century ago, we were taught by a group of people who called themselves the legal realists that formalism is impossible. It's impossible to simply discern premises of a judge and reason to determine conclusions. Inevitably, justices and judges have discretion. Originalists want to hide it. But I hope I've shown you tonight, they exercise discretion just as much as liberal justices. And besides, no constitutional right is absolute. The government can engage in race discrimination or infringe free speech or interfere with any right if it has a compelling interest. But what's a compelling interest? The government can always draw distinctions among people without violating protection if it has at least a legitimate interest. What's a legitimate interest? What's compelling or important or legitimate? Or what's an unreasonable search and seizure? So much comes down to the values of those who are on the court. No one, originalist or non-originalist, can avoid that. And so I fear that over the course of these 3 lectures, I've painted a very disturbing picture about our current court and where it's going to go. And it's intentional because I am very worried about what the Supreme Court is doing and what it's going to mean for our society. At this moment, the Supreme Court has its lowest approval ratings of at any point in American history since this started to be measured. In a Gallup poll in June of 2022, only 25% of the American people expressed confidence in the Supreme Court. In a Marquette University poll in July of 2022, 61% surveyed expressed disapproval of the Supreme Court. And so I think a crucial question for all of us is, at a time when our country is so deeply politically polarized, what will it mean to have a court that's come down so solidly on one side of that divide? And then the question becomes for each of us, all of us, what do we do about it? How do we go about protecting our rights in light of a court that's going to be conservative for a long time to come? And the court is going to be conservative for a long time to come. Think of the ages of the conservative justices. Clarence Thomas is the oldest at 74. Samuel Alito is soon to turn 73. John Roberts is 68. Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett are all still in their 50s. I've long thought that the best predictor of a long lifespan is getting confirmed for a seat on the Supreme Court. John Paul Stevens didn't retire until he was 90. If Clarence Thomas stays on the court until he's 90, he'll be a justice for 47 years. Or to put it another way, Amy Coney Barrett was 48 when she was confirmed for the court in October 2020. If she remains on the bench until she's 87, the age which Justice Ginsburg died, she'll be a justice to the year 2059. So in the face of this, what do we do? Well, one thing we're going to need to do is turn more to state courts and state constitutions to protect our rights. The law is clear. State courts using state constitutions can provide more protection for rights than the Supreme Court finds under the United States Constitution. In 1977, Justice William Brennan wrote an article in the Harvard Law Review urging the use of state constitutions by state courts to protect rights. He did so in response to the Supreme Court having become much more conservative after the retirement of Chief Justice Earl Warren and the appointment of Chief Justice Warren Burger and 3 other Nixon appointees. The court today is vastly more conservative than it was in 1977, so it becomes even more important to look to state courts and state constitutions to protect rights. This isn't new. The Supreme Court ruled in 1973 that there's no right to education and disparities in school funding don't violate the U.S. Constitution. But the California Supreme Court in Serrano versus Priest found that there is a right to education in California, and disparities do violate the state constitution. State Supreme Courts in Arizona, Texas, New Jersey did the same thing. Now, when I say this, you might think, well, that's all well and good living in California. The California Supreme Court is much more progressive than the U.S. Supreme Court. But what about all those red states? Here, too, I think there's reason for hope. A week ago today, the North Dakota Supreme Court declared unconstitutional is violating the North Dakota state constitution, the state law prohibiting abortion. North Dakota is very much a red state. Its judges face elections. And yet, the North Dakota Supreme Court found that the law prohibiting abortion there violated the state constitution. In January of this year, the South Carolina Supreme Court found that the South Carolina statute prohibiting abortions violated the South Carolina state constitution. Again, very much a red state and elected judges who nonetheless protected more rights than under the United States Constitution. These cases will hopefully be a model for greater protection of rights. If you think back to how the right to marriage equality started, it wasn't in the federal courts, it wasn't in the Supreme Court, it wasn't in the United States Constitution. In 2003, the Massachusetts Supreme Judicial Court found that the state law prohibiting same-sex marriage violated that state's constitution. Soon after, the Iowa Supreme Court, 5-0, found that the state's prohibition of same-sex marriage violated that state's constitution. And here in California, May of 2008, the California Supreme Court found that the prohibition of same-sex marriage here violated the state constitution. I don't want to exaggerate the role of state constitutional law. Obviously, if the Supreme Court says that something is unconstitutional, then states can't make it constitutional. If the Supreme Court says that gun regulation violates the U.S. Constitution, the realm of what state courts can do is quite limited. But when it comes to expanding our rights, I think all of us need to think about how can there be more litigation under state constitutions in state courts. Second, we need to look to the political process. There have been times when we've relied on the judiciary, but we need to think about how can we use city councils, state legislatures, and yes, even sometimes Congress to do a better job of protecting our rights. Again, I can give you a recent example. After the tragic death of George Floyd in May of 2020, there were protests against police violence in literally every state. These protests occurred notwithstanding the quarantines for COVID at the time. The protests had real effects. Focus just here on California. After the protests, for the first time, California adopted a law prohibiting police use of chokeholds. California's legislature changed the standard for when police can use deadly force. Under the U.S. Constitution, police can use deadly force if it's reasonable under the circumstances. California law now says police can use deadly force only if it's necessary under the circumstances. After the death of George Floyd, the California legislature adopted a law requiring that police officers intervene to stop misconduct and excess force going on by other officers, a duty that never before existed. Throughout the country, cities and states adopted laws then to provide more regulation of police. A bill passed the House of Representatives. It died in the Senate. But even without federal action, there was progress towards police reform. and it's continued. A year ago, the Colorado legislature adopted a law abolishing qualified immunity as a defense for police officers when they're sued for excess of force in Colorado courts under Colorado law. Qualified immunity, as you may have heard, is a doctrine that says that a government official can be held liable for money damages only if he or she violates clearly established law that every officer should know. During the protests against the death of George Floyd, there are many signs abolish qualified immunity. One of the things the bill in Congress had done was significantly change the standard for qualified immunity. That didn't pass, but the Colorado legislature has adopted a law abolishing qualified immunity in state court. In fact, just this year, the Nevada Supreme Court, under Nevada law, took away a qualified immunity as a defense for police officers. So we need to think about ways to mobilize, to use the political process, to not rely on the courts to protect our rights. Third, we need to think of ways, where possible, of making arguments for progressive results that can persuade even this conservative court. We need to think of ways of making arguments for progressive results using originalism to justify our conclusions. And sometimes it works. I'll give you an example, though it's not in the constitutional area, where this conservative court came to an incredibly important progressive conclusion. The case is Bostock versus Clayton County, Georgia, in June of 2020. It involves Title VII of the 1964 Civil Rights Act. That law prohibits employment discrimination on the basis of race, sex, religion. And the issue in the case was, does discrimination on the basis of sexual orientation or gender identity violate Title VII? There were 3 cases that came to the Supreme Court together. 2 involved gay men who were fired when their employers learned their sexual orientation. And the other involved a transgender woman who was fired when she transitioned. The Supreme Court, in a 6-3 decision, held that discrimination on the basis of sexual orientation and gender identity violates Title VII. Justice Neil Gorsuch, one of the most conservative members of the Supreme Court, wrote the majority opinion. And he did so focusing on the text of the statute. He said, as to the 2 men who were fired for being gay, if they had been women in relationships with men, they would have had their jobs. But because they're men in relationships with men, they lost their jobs. That's sex discrimination. He said if Amy Stevens, the transgender funeral home director, was still male, she would have her job. But because she's female, she lost it. Justice Gorsuch said, following his very conservative textualist approach, that therefore this violates Title VII. Now, I'm not naive. I've told you what the Supreme Court did last year and was likely to do this year. That doesn't mean that originalist arguments can or even usually will win. But we need to find ways of making arguments in the terms that the Supreme Court will listen to. Finally, I think it is so important to develop a progressive approach to the Constitution. In the early 1970s, after the Warren Court, conservatives began their project of developing a conservative theory of constitutional interpretation. Originalism grew from it. Robert Bork wrote a famous article in 1971 where he articulated what we know as originalism today. The Federalist Society developed, and it promulgated the theory of originalism and worked hard to put conservatives on the Supreme Court and the lower federal courts. It's essential now that we develop a progressive theory of constitutional interpretation and work as the Federalist Society did to make sure that there are progressives on the Supreme Court and all courts. So I'm often asked by my students, what gives me hope for the future? Admittedly, I've never seen my students, or at least some of them, as discouraged they are right now about the Supreme Court and the Constitution. And of course, I immediately answer what most of all gives me hope for the future is them, my students. But I say also what gives me hope for the future is something that the late Dr. Martin Luther King Jr. said. He remarked that the arc of the moral universe is long, but it bends towards justice. And I say to my students, if you think about race in American society, there's still such a long way to go. But think about it compared to where we were in 1787 or 1868, or even the year I was born, 1953, when there were still Jim Crow laws throughout the South and much of the North. I say to my students, think about sex discrimination. At the law school I attended in 1970, only 5% of the first-year law students were women. Today, at the law school where I'm dean, 63% of the first-year law students are women. Or think about sexual orientation. As with race and sex discrimination, there's still so far to go. But it's not quite 8 years ago, in 2015, that the Supreme Court for the first time held that state laws that prohibit same-sex marriage are unconstitutional. It's not quite 3 years ago that the Supreme Court said, as I just pointed out, that employment discrimination based on sexual orientation or gender identity violates federal law. And so I say to my students that the arc of the moral universe is long and it bends towards justice, but it's only going to happen if they work to make it happen. I say to my students, and I'll say it at commencement at Berkeley Law on May 12th of this year, that if they're discouraged, there's really only two choices. We give up or we fight harder. And when phrased that way, it means that for all of us who care about these things, there's really only one choice: to fight harder and better than we ever have before. Thank you. And they will come to you for questions because the lights, it's very hard for me to see you. So I'll do my best when you're asking to find you.
Thank you so much for this talk and this series. Could you give us some of your thoughts on some of the solutions other people have come up with in terms of increasing the members on the Supreme Court or having term limits so it's not a lifetime appointment? Thank you.
Sure. Thank you for the question. I would favor those reforms, but they're not going to happen in the foreseeable future. Let me start with term limits. I strongly would favor and argued many years ago for 18-year non-renewable terms. Why? Well, thankfully, life expectancy is a lot longer today than it was in 1787. In 1787, average life expectancy was 37 years. Here's a statistic that to me is quite stunning. From 1787 to 1970, the average tenure of a Supreme Court justice being on the bench was 15 years. And I was surprised to see that it remained constant through the 19th and well into the 20th century. For justices who have been appointed since 1970 and have left the bench, their average tenure is 27.5 years. Go back to the example I mentioned of Clarence Thomas being appointed in 1991 at age 43. If he stays till he's 90, he'll be justice for 47 years. So that doesn't sound ideological. Elena Kagan was 50 when she was appointed to the court in 2010. If she stays till she's 90, that's 40 years on the bench. That's just too much power in one person's hands for too long a period of time. Also, as I said in my introduction, too much depends on the accident history. Richard Nixon was able to pick 4 justices in his first 2 years as president. Jimmy Carter got no picks in his 4 years as president. 18-year non-renewable terms with a vacancy every 2 years will let every president have an equal say in the composition of the court. I believe, though, that term limits would require a constitutional amendment. There are some who disagree, and we could talk about that. And I think there's bipartisan support for term limits. The problem is I don't think there's any constituency that cares enough to do the work for the constitutional amendment. As to the size of the Supreme Court, the size is not set by the Constitution. It's set by federal statute. It's varied from 5 to 10 over the course of American history. 9 is a historic accident. It had gotten to be 10 justices, and there was a terribly unpopular president after the Civil War, Andrew Johnson. He'd been impeached by the House of Representatives, and Congress didn't want him filling a seat on the Supreme Court, so Congress passed a law saying the next time there's a vacancy, We're abolishing that seat on the Supreme Court. And it became 9, and it's been 9 ever since. There's no way with the current Republican House they're going to vote to expand the size of the Supreme Court with a Democratic precedent. Correspondingly, even when Democrats had both the House and the Senate in the prior 2 years, Republicans would have filibustered any attempt to expand the size of the Supreme Court. There may be a point where the Supreme Court is so out of touch and its rulings are regarded as so dangerous that there'll be popular support for expanding the size of the Supreme Court. But I don't think that's going to happen, at least in the foreseeable future.
Thank you. Dean, thank you for coming.
Thank you.
I wanted to ask about Thomas's opinion in the Dobbs decision. He mentioned 3 court cases that are ripe for overturning, and I note that they none of them purportedly or ostensibly apply to him, and I was wondering if you think he accidentally omitted Loving.
Many people have pointed out that he targeted Obergefell, the same-sex marriage case, but he didn't mention Loving versus Virginia, the interracial case. Maybe it was hypocrisy on his part, self-interest. Maybe it was he would justify it by saying that laws that prohibited interracial marriage were based on a racism that he sees as violating equal protection, but he didn't believe that the homophobia that led to laws prohibiting same-sex marriage violate equal protection in the same way. But you're right, the 3 examples he gave were Griswold, Lawrence, and Obergefell.
From the vantage of your specialty, do you think it was beneficial to have a president who taught and presumably studied constitutional law?
I think everybody should study the Constitution. I don't think that constitutional law should be the province of constitutional law professors or lawyers. The Constitution, as I said at the beginning tonight, so affects all of us in the most important and intimate aspects of our lives. One of the things that I worry about is that our society does a poor job of civic education. And I think it's so essential that we find ways of teaching children about the Constitution. How can we rely on them to protect constitutional rights in the future if they don't understand the Constitution? So, yes, we've at times had presidents who've studied the Constitution. Barack Obama taught constitutional law at the University of Chicago Law School. Bill Clinton taught constitutional law at the University of Arkansas Law School. But I don't think that that's a prerequisite for being president. I think an understanding of what the Constitution is about is crucial. The late Justice Louis Brandeis wrote an opinion in 1928 in Olmsted versus United States that had words that I think are really important in answering your question and words that we should all remember. Brandeis, in that opinion, was rejecting the view that the Fourth Amendment applies only if there's a trespass, the view that Justice Thomas took just a few years ago. And Brandeis said, the greatest threat to liberty will come from people acting for what they perceive as beneficial purposes. He said, people born to freedom know to resist the tyranny of despots. He said, the insidious threat to liberty will come from well-meaning people of zeal with little understanding of what the Constitution is about. And your question says to me why it's so important that all of us understand the Constitution.
Hello. Hi, I have a question. One of, if it could be called a strength of originalism, is that it gives some kind of maybe legitimacy to, or how do I put this? Some kind of democratic legitimacy to an opinion that's founded on maybe the legislative history at the time. It seems like your epistemological problem seems to invalidate this, though. Do you feel like there's any kind of method of interpretation that would grant the court some kind of democratic legitimacy that maybe in the appointment it lacks?
Let me respond in a couple of ways. First, is to disagree that originalism gives the court democratic legitimacy. None of us alive today, and for most of us, nor were our ancestors in the United States in 1787 or 1791. Why believe that interpreting and enforcing a document from 1787 or 1791 in the views of that time is democratic? The Constitution is inherently anti-democratic. What makes the Constitution different from all other laws? It's so very difficult to change. Well, why should we as a democracy be governed by a document that was written long ago and that we can't easily change? I think it's because of the values of having a constitution like that. And I believe in the values of having court to give meaning to the Constitution. But I don't think that applying what people thought in 1787 is democratic. I don't think that the Supreme Court following what framers of the Second Amendment thought in 1791 is democratic. In fact, the second thing I want to say is, in fact, when the court is using originalism to strike down what Congress, state legislatures are doing now, is inherently anti-democratic. When the Supreme Court strikes down gun regulations that are adopted by legislatures, or affirmative action that's adopted by legislatures, that's anti-democratic, not furthering democracy. But finally, what I would say is that even if we wanted to embark on finding the original meaning, almost always what we'll do is discover there are questions that they didn't think about, or even if they did, they didn't agree about. What can Congress spend money on? James Madison thought Congress can only spend money to carry out the specific powers in Article 1, Section 8. So he took the position that Congress couldn't adopt disaster relief after fires or floods and things like that. Alexander Hamilton thought Congress can tax and spend for any purpose and can then adopt things like disaster relief. How do we know what the framers' intent is when James Madison and Alexander Hamilton thought about it and disagreed? Let alone how are we going to apply originalism for all the things they never thought about? So that's my response in terms of the relationship between originalism and democracy.
Yes, unfortunately, through my entire education, I never took a course on the Constitution. And I've gone to graduate school and all the rest, but I did see a play on Broadway called What the Constitution Means to Me. I don't know if you're familiar with that play,
Yes, sir.
but they suggest in that play that we just get rid of the Constitution and rewrite it. And I was wondering what you thought of that notion and those possibilities.
I also saw the play. I saw it when it was starting out at the Berkeley Rep, so I'm not sure how it changed by the time it got to Broadway, but it was very powerful, and if you haven't seen it, I recommend it. And it started with the story of the playwright being in a contest, and I forget what group sponsored the contest, where she had to answer the question, what the Constitution means to me. I think it's time to begin talking about the idea of writing a new Constitution. I think that there's a lot that's very frightening about it. How will we decide who is doing this? How will we decide whether it's ratified by the procedures in the Constitution or different procedures? Is it possible that those with different values than ours will capture the process and be a far worse document? Or can we hope that if we were to create a new Constitution, the people involved in it would live up to their role? Those who did this in 1787 were not saints. There were 55 white men. A significant minority of them were slave owners. Some of them were very involved. Some of them were minimally involved in the Constitution drafting process, but they still produced a brilliant document. Couldn't we have a group of people today do that? I am, to be clear, not saying it's time for a new Constitution. I'm saying something much more modest than that. Maybe it's time to begin thinking about the process for drafting a new Constitution, a Constitution that's much more adapted to the world we live in the 21st century.
Thank you for your great talk here. Thinking back over the last few years of many dispiriting and horrifying acts of this court, I keep coming back to the one that I find most dispiriting and most horrifying is SB 8 from Texas. because that seems to me to have been to sort of eradicate the idea of rule of law altogether. And I wonder if you'd comment on that and how that fits in with this court in terms of their originalist doctrine. Thank you.
In which case could you say again that you're referring to?
SB 8, the Texas case.
Okay, I'm very familiar with it. Texas adopted a law, it was scheduled to go into effect September 1st, 2021, that said it prohibited abortions after the 6th week of pregnancy. And at this time, Roe versus Wade was still the law protecting a right to abortion to viability of the 23rd or 24th week pregnancy. And it said that anyone could sue a doctor, anyone who performed or aided and abetted abortion, and recover $10,000. And the case is called Whole Women's Health versus Jackson. And the Supreme Court, in a 5-4 decision on September 1st, refused to enjoin SB 8 and allowed it to go into effect. And then in December of 2021, the Supreme Court decided Whole Women's Health versus Jackson. Justice Gorsuch wrote for the court, and it was 5-4, and he said, you can only sue a state official for an injunction if the state official plays a role in enforcing the law. He said, state officials don't play any role in enforcing SB 8. SB 8 authorizes suits against doctors and those who aid or abet abortions. It's not like the Attorney General of the state or the district attorney is bringing enforcement actions. So the court said, you can't sue to have SB 8 declared unconstitutional. Now, that doesn't mean there's no way to challenge it. If somebody is sued, as a defense, they can argue the law is unconstitutional, but that takes somebody courageous enough. And of course, now we know the Texas law is constitutional because states can prohibit all abortions. All this might sound real abstract, so let me give you examples. Imagine that a state adopts a law that says anyone who performs a same-sex wedding can be sued and is liable for $100,000. Can you go to court and get an injunction saying that clearly violates the Constitution because the Supreme Court has said the right to same-sex marriage? No. The Supreme Court's decision with regard to SB 8, Whole Women's Health versus Jackson, says if no state officials enforce the law, you can't sue anyone for an injunction. The only way to challenge the law as unconstitutional would have somebody courageous enough to violate the law, risk getting sued, and then argue as a defense. Or imagine a state adopts a law that says anyone who criticizes the governor of the state is liable for $1 million. Clearly unconstitutional. But since it's not enforced by the Attorney General or district attorneys bringing prosecutions, the Supreme Court's decision says the only way to challenge it for somebody courageous enough to violate it, and then they can argue it's unconstitutional as a defense. In fact, last summer, the California legislature adopted a law creating civil liability for certain gun offenses. Among other things, makes it you're civilly liable if you sell a handgun to a minor under 21 or a rifle to a long gun to a minor under 18, and no one can go to court to challenge that as violating the Second Amendment because it's just civil liability. I share your sense that this is very frightening because it gives to the states the ability to adopt laws that violate the Constitution, and there's no way to get them declared unconstitutional through an injunction. You just have to have somebody who's going to be courageous enough to violate it and then argues defense it's unconstitutional. I think the Supreme Court's decision was very much based on the antipathy of the 5 justices in the majority to abortion rights, but it led them to articulate a legal principle that transcends abortion rights and really is a loaded gun that's there for state legislatures to use to take away rights in the future.
Yeah, I'm curious about, I'm here. Go to your left.
That's okay.
Turn left.
I apologize.
from-
The lights really are very bright, so it's hard for me to see, but I can hear fine.
Oh, I'm here.
Thank you.
You're from Berkeley, so go left here. Yeah.
Okay, you got it.
Yeah. I'm curious about your students these days, what they're interested in. Does anybody talk about public interest law anymore?
Absolutely.
Okay, that's good.
Of last year's graduates at Berkeley Law, and these are those who graduated in May of 2022, 24% went into government or public interest positions. So I think it shows this summer we will be funding about 325 rising second year and third year students to work at public interest organizations. I just got that number this morning. So the students are passionate. Of course, we prepare students for the whole range of legal practice. Over half our class will go to law firms that have over 100 lawyers. About 20% of our graduating class will go and do judicial clerkships, and then we'll see what they do. But a quarter went into public interest and government work. I think we as a law school, or law schools more generally, have to take steps to facilitate that. Grants during the summer, fellowships after graduation, loan forgiveness. But I find that many of the students come so deeply and passionately committed to pursuing justice. And when I say that they are my hope for the future, I'm not being flippant and it's not hyperbole.
Thank you. How did the originalists explain away Thomas Jefferson's viewpoint that there's a separation of church and state implied in the First Amendment?
Thomas Jefferson is the one, as you point out, who coined the phrase that there should be a wall that separates church and state. He did so in the context of debate of whether Virginia should have taxes to support churches. I recently did a program with an originalist law professor, Michael McConnell, and he says flat out that he believes that Jefferson's views weren't the original meaning of the Establishment Clause. Jefferson was not involved in drafting the Constitution. Jefferson was in France at the time the Constitution was drafted. If you've seen the play Hamilton, and you remember Cabinet Debate #1, Hamilton mocks Jefferson for being off in France when the Constitution was drafted. And originalists reject the idea that there's a separation of church and state. Originalists say that the meaning of the Establishment Clause was to allow the government to be accommodating to religion and religion accommodated in government. And Professor McConnell is a very prominent originalist, just rejects the idea that Jefferson's views reflect the original meaning of the First Amendment.
I have one basic question for you. If a citizen were to sue the Supreme Court to allow them to have guns in the Supreme Court chambers, wouldn't their viewpoint have to be to allow it?
No. From 1791 to 2008, not one federal, state, or local law was struck down as violating the Second Amendment. In District of Columbia versus Heller in June 2008, the Supreme Court for the first time found a law to violate the Second Amendment. It was a D.C. law that prohibited private ownership or possession of handguns. Justice Scalia wrote for the court and said, the Second Amendment is not absolute. The government can, among other things, prohibit guns in sensitive places like airports, schools, and courthouses. And I think the Supreme Court would say, and should say, that there can't be guns in the Supreme Court or in any court or airports or schools. I don't think the Supreme Court is going to take an absolute position with regard to the Second Amendment. On the other hand, the Supreme Court, as I said in June of last year, said there is a second right to have guns in public, including concealed weapons. I can't.
How is that not a misread of the Second Amendment? And just prima facie for its language.
The question was, why isn't that a misread of the Second Amendment's language? I think it is. The Second Amendment says, quote, a well-regulated militia being necessary to the security of free state, the right of the people to keep and bear arms shall not be infringed. From 1791 to 2008, in the handful of Supreme Court cases about the Second Amendment, the justices always said the Second Amendment means what it says. It says it's about a right to have guns for malicious service. Justice Scalia rejects that in the case I just mentioned, District of Columbia versus Heller, and he says, and I'm quoting here, that there's a prefatory clause and an operative clause to the Second Amendment. He says a well-regulated militia being necessary to the security of the state is just the prefatory clause. He says the operative clause is the right of the people to keep and bear arms shall not be infringed. And he says a prefatory clause can't undermine the meaning of the operative clause. But I've quoted almost verbatim. Justice Stevens, in his dissent, says that it's all operative language. You can't read half of the Second Amendment out of the Constitution. That Justice Scalia wants to read the Second Amendment as if it said, the right of the people to keep and bear arms shall not be infringed. But what about the first half of the Second Amendment? And that's what your question goes to. And as I say, from 1791 to 2008, your view was the one the court adopted for the Second Amendment, but no longer is that so.
Hi. Kind of related to that last point, do you think that the Supreme Court, using that theory that they developed with the Second Amendment now, do you think they're going to uphold laws such as the one in Texas that are broadly unpopular with the public and continue to give gun rights back to people such as domestic abusers?
My hope is that the United States Supreme Court is going to reverse the Fifth Circuit, that the Supreme Court's going to say that in 1791, people who were deemed as dangerous could be kept from having guns, and therefore the federal law that says that those under restraining orders in domestic violence cases can't have guns, that law is constitutional. On the other hand, the Fifth Circuit decision was written by very conservative judges. It was 3-0. It was Trump appointees were two of them. And so, I mean, we can't be sanguine about what the Supreme Court is going to do in that regard. The Supreme Court's decision from last June in Bruin has led to a lot of other laws being challenged that the Supreme Court will uphold. There's a federal law that says you can't sell, distribute, or possess a gun without a serial number, a ghost gun. Two federal courts have declared that unconstitutional, saying that there were no laws prohibiting ghost guns in 1791. Well, you can see where this is going. And my hope is that the Supreme Court will back away from the extreme originalist position of Justice Thomas' opinion in Bruin, but we'll see. You at least have the opportunity. You see how lower courts have taken what the Supreme Court has said. And people are going to die because of this decision, especially women are going to die because of this decision. And I hope the Supreme Court will focus on that.
This will be the last question. Thank you. Hi. I wonder if you have a favorite Supreme Court justice in history, and maybe one you would like to see the current justices model themselves on.
Sure. I would pick two. John Marshall, because he's so much the architect of constitutional law. Marbury versus Madison being an example. I quoted McCulloch versus Maryland, and so much else. And the other is Louis Brandeis. I think he's the best writer to have ever served on the court. And I think that so many of his opinions can guide us today. He wrote the most eloquent defense of free speech in a case called Whitney versus California. He wrote the most eloquent defense of the right to privacy and the right to be alone in Olmstead versus United States. And so if I was to pick two justices, they would be the ones I would start with. Thank you. And with that, I'll take that as the chance to say thank you so much for coming. My enormous thanks to the Hammer Museum for having me. Thank you.